My name's Marissa Allen and I'm a solicitor in the private client team at DMH Stallard.
My name's Catherine Culverhouse and I'm a partner in the Wills, Trust and Estate Disputes team. So I've seen a rise in disputes between executors. The decision as to who to appoint as your executor is a really important one.
Absolutely. So when I speak with clients, there are a number of factors to consider when you're choosing who to name as your executors. The first one is eligibility. So your executor needs to be over 18. And ideally, I say to clients, your executor should be younger than you.
That's quite hard depending on the age of the person making the will. If you're a young testator, then you're going to struggle to find someone who is over the age of 18, but also has the capacity and ability to be able to act.
Definitely. And I think you should be keeping your will under review. It should be something that you're looking at every couple of years. Do I still trust the person that I've named as my executors? Do I still have a relationship with them? Do they still have the required skills to act? And I think that's the other step. Do they have the skills to act and are they willing to act? So just because you've named somebody as your executor doesn't mean that they have to accept the appointment. They can say, no, I don't want to. So having that conversation with them, letting them know that you've named them, it's a really important role, and it's something that can last a number of years. So do they understand that? Do they want to take on the role? And also, do they have the required skills to be an executor?
And I guess coming into that, so if someone is named as an executor, circumstances in life change. It could be a long time between you making your will and actually the role coming into force when you've passed away. So I assume it's good to have some replacement executors who can act if the first person named can't.
Definitely. So you want to have people that you trust, that if your named executors can't act, you've got somebody else that can step in. Your named executors might have died, might have lost capacity and just can't take on that role anymore because their circumstances have changed. So not only naming executors that you trust, but having good replacement executors named as well. And I think who you name and the skills required as an executor vary depending on the nature of your estate, the nature of your family setup and the complexity of your assets. So do you have business assets, agricultural assets, complex investments within your estate? You need an executor that's organised but really has the ability to deal with potentially complicated assets.
If your estate is a really complex one, always also consider having a professional executor who will have the skills and knowledge to kind of take those roles forward.
Yeah, absolutely. That's really important. Who is going to be able to make those decisions, in relation to a business, the running of a business after you've died? Is the person that you've named able to make those decisions on behalf of the estate? And another really important factor is communication. So can your named executor communicate effectively, not just with, financial institutions, but most importantly with the beneficiaries?
Yeah, and often lack of communication is one of the biggest factors that leads to a dispute, because if the beneficiaries aren't being communicated with, they don't know where they are with the estate, they start to wonder, is it being dealt with properly? What's going on? Where's my money? And that can be the catalyst for that dispute.
Yeah. I think one of the questions that a lot of clients ask is, can I name my children as executors? They're beneficiaries of my estate. Can they also be the executors? And the answer to the question is yes, they can be. There's nothing that prevents them from being the named executor. But are they suitable for that role? Do they get along? Can they make decisions together? And can they also act impartially?
Yeah, absolutely, because an executor should remain neutral, should act in the interests of all of the beneficiaries and the estate as a whole. And if your beneficiaries and your executors are the same person, then that can often lead to a conflict. Are they then able to act in the interests of everyone, or are they going to put their own interests first without even realising it sometimes?
I think clients are quite reluctant to exclude their children. They're concerned that it's going to cause upset after they've died. It's sort of, I'd rather just name them and avoid upset. What I will often say to clients is make them aware, make your children aware. If you're not naming them, or you're naming an independent, or you're naming one of your children as your executors, why have you done that?
Yeah, absolutely. Conversations are the most important factor when it comes to disputes. So if you've told your family what you're doing in your will, and they're aware of everything, then it's much less likely that there is going to be a dispute at the end. And what I would also say is, you may be worried about upsetting your children, but actually, if they're in a situation where they're in a dispute after your death, when it's already an upsetting time, that is going to cause a lot more damage to your family dynamic than you having a careful discussion with them now. And I would also say that actually you can phrase it in a different way. So you can almost say, you know, acting as an executor is a really difficult role. It's very involved. I want to take that off you. So I'm going to appoint an independent executor, or I'm going to give it to, you know, one of the children, whoever they may be, because they're more suited. They've got more time, or they've got the expertise. And that can often be enough to kind of resolve any future dispute.
And I suppose if you don't feel that you can have that conversation with your family during your life, my recommendation would be put together a side letter to sit alongside your will to clearly explain, I have considered you, and these are my reasons why you're not named.
Yeah, and I think another thing too, where there is a dispute, you know, all of your executors have to agree on decisions. It's not a majority rules. So if you've got 3 executors and 2 of them have an agreed way forward, but the third doesn't agree, then actually that is still a dispute, and you're going to end up with an application to the court to decide that one particular issue, if it's that's in dispute, or the executors being removed with an independent executor coming in. And that will lead to delays in the administration of the estate, costs, and it's a rather unpleasant situation that will destroy a family dynamic.
So in some situations, having one independent acting with the children can help, but actually if you don't think your children are ever going to agree, to avoid that deadlock situation, it's probably better to have an independent executor, 1 or 2 independent executors, to be able to act in the best interest of the estate.
Absolutely. And I think that's the important factor. It's making sure there's someone there who can carry out your wishes. It's not the case that you're just trying to please everyone. Ultimately, the important thing is that your estate is administered correctly and with a trusted person.
Speak to your solicitor about your family circumstances, be honest with them, and take their advice.
Absolutely.